Good afternoon. I want to welcome everyone to our May 13th City of Little Rock Board of Directors agenda meeting that will set the agenda for May the 20th. I want to welcome those that are watching and streaming at home and online. We'll now have our Mental Health Awareness Month proclamation. It's been a while. Members of the board, as we come to recognize mental health awareness, so we'll read our proclamation. Whereas mental health is essential to the overall well-being and success of individuals, families, and communities, and affects people of all ages, races, genders, and backgrounds. And whereas 1 in 5 Americans experiences a mental health condition each year, yet stigma, lack of access, and misinformation continue to prevent many from seeking the care and support they need. Whereas the City of Little Rock recognizes the importance of raising awareness, eliminating stigma, and promoting open conversations around mental health and wellness. And whereas the community-based mental health resources, culturally competent care, equitable access to treatment are vital components in building a healthy, resilient, and inclusive city. And whereas by designating May as Mental Health Awareness Month, we reaffirm our commitment to supporting the emotional and psychological well-being of all Little Rock residents and encourage everyone to check in on themselves and one another. Now, therefore, I, Frank Scott Jr., Mayor of the City of Little Rock, Arkansas, do hereby proclaim May 2025 as Mental Health Awareness Month. Oh. Do you want to say anything? I know this is one of your ministries.
Perfect. Okay. Okay, perfect. Hi, my name is Presley Bennett. I am one of the teens that works with Kennedy Stanley, and so I'm happy to accept her proclamation. We're so proud of her work. Yes, thank you so much. Okay, absolutely. Thank you so much.
Got one more.
Awesome, thank you.
Thank you.
So much.
All right. I think we'll see the M1 resolution and consent agenda items 1 through 22. Any questions? Director Miller?
Thank you, Mayor. I had a chance to take a look at the information we received. I don't know, is there generally a sketch, some more board communication? I mean, there's generally some more attachments to
For which one?
all of them. All we have is a resolution. I see the write-ups on 27, 28, but there's no other write-ups on anything else.
Queen, if just maybe hit refresh.
Okay,
Yeah, it should be there. And if not, we'll get that to you.
okay, thank you. You got those.
We'll get that to you this afternoon.
Okay, thank you.
All right, Director Hines?
I guess this question's on number 6 for John. John, I gathered from the write-up, we're doing more than just sidewalk repair at $900 a foot on number 6, Indian Trail.
Director Hines, yes, this is not repair. This is actually constructing new, non-existing sidewalks. So it involves walls, curb and gutter, and some other stuff to be able to actually create the sidewalk path
Okay,
down
so-
Indian Trail.
Can you send me the bid tabulation sheet on that?
Certainly. We'll get
And
you a
what's,
copy of the plans as well.
Yeah, and what's our reserve on that, our contingency?
We typically do, is it 20% contingency?
Thank you.
Director Lewis?
Hey, John, while you're up there, do you mind elaborating on number 1? I understand it's a widening project, but I just want for the public to hear what is going to be taking place out there. Arthur Lane, Gamble Road.
So this is going to be a road reconstruction project. So we'll actually be improving the road so it meets our current city standards for a residential street. So that'll be curb and gutter, drainage, pavement improvement. So it'll look like a street that's built brand new.
Perfect. Any timeline you can give?
Not at this point. It'll depend on getting all the paperwork put in place, notifying the contractor when they can start, and then they typically have anywhere from 6 months to 9 months for this scale of project to actually construct it. So you're probably looking maybe the end of the year, best case scenario, to be complete.
Perfect. Thank you. I just wanted you to state that so it's on public record in case someone says that they were not informed.
Okay.
Director Adcock?
Yes, item number 20. What is going to be the use of this property?
Kevin, if you'll share that one.
Is this an individual that we're giving the property to? Is this an organization?
The property is being donated to the city, Director Adcock.
Okay. Is it going into?
It'll be going to the land bank, yes, ma'am.
Thank you.
Any questions on planning items 23 to 25? Director Miller?
Thank you, Mayor. I'd like to see a presentation on 20, I think it's 25. Somebody do that and show me. I don't have drawings or anything, but that's fine.
25, this is to set the public hearing.
So I can visit with you later and get all the information.
Yes,
I can
sir.
see it. And,
Yes, sir.
okay, all right, thank you.
All right. Any questions on items 26 through 28? Any questions on items 26 through 28? Director Adcock?
I'd like a presentation on 27 and 28, since we've got so much correspondence on those.
Yes, ma'am. We'll have a presentation from Mr. Jordan on 27 and 28. If you combine those together.
Sure. Number 27, Z9891-B. Several residents living on North Woodrow Street, represented by the Barber Law Firm, are appealing the Planning Commission's actions in approving a special use permit to allow a group home on the R3 zone property at 205 North Woodrow Street. The Planning Commission voted 7 yes, 0 no, 2 recusals that were by Commissioners McDonald and Hodges. 1 person was absent, and we had 1 open position. This is for 11 residents in this home on Woodrow. Home is 4,650 square feet or so. They have parking for the residents, parking for staff out front. There's another one that is also on appeal through the same group, the Tenon Group, which is number 28, and that is Z9892-B. This is David and Beth Deere are appealing the Planning Commission's actions and approving a special use permit to allow a group home on the R2 zone property at 822 North Monroe Street. That's located in Ward 3. Planning Commission voted yes, 7 yes, 0 no's, 2 absent, and 1 open position. This is for 8 residents here. This home is 2,800 square feet, 2 staff parking off-street, and then 6 parking for the residences on-street.
Are these close to each other?
They are close to each other, yes, ma'am.
And how many people are in this second one on 28?
On 28 is 8 people.
8 people, and the 27 is 11 people?
It's 11 people, yes, ma'am.
Okay. And what type of homes are these?
These are group homes. These are homes for, I don't know if they have substance abuse problems. I don't know if it's alcoholism or substance abuse as a whole, but they're homes to allow people with substance abuse problems to live in a neighborhood setting.
Are these young people or just adults?
I don't know what the age range is for that, ma'am.
Thank you. Thank you.
Director Wyrick?
Thank you, Mayor. I have a couple of questions for the city attorney. One of them is, Tom, on our ordinances today, we have, I think, an ordinance that says that if we have 4 unrelated people in a single-family home, that is a by right use.
We have a definition of family, which will either include blood relatives and doesn't have a limitation, or it can be 4 unrelated persons would be considered a family, or if it is a group home, it is presumed to be 8 unrelated persons.
Okay. Do we have a definition in our ordinances that speaks to necessity, or that speaks to reasonable accommodations?
We have the provision about 8 homes being presumed to be, 8 persons being presumed to be a family as a reasonable accommodation based upon decisions from the U.S. Court of Appeals for the 8th Circuit pursuant to the Fair Housing Act and the Americans with Disabilities Act and concomitant provisions from the Arkansas Code.
Can we get a copy of that?
Yes, I'm sending out a little memo to y'all by the end of the week for.
Okay, okay. And then what about necessity?
The
Now,
question on necessity is really not there, because the issue in the Americans with Disabilities Act is that if a person has a life-altering condition or is thought to have a life-altering condition, which includes alcoholism and substance abuse addiction, then a locality is not free to impose rules that would discriminate against that group based upon the medical reason, the disability, which is what those 2 things are, substance abuse and alcohol addiction. So necessity is really not a part of that equation. The types of things that are parts of that equation deal with parking, they deal with traffic, they deal with noise and things of that nature, as this board has addressed in the past.
Okay, I got that, those questions from a lawsuit that was overturned in Anoka, Minnesota, and that was part of the reason why it was overturned was necessity and then also reasonable accommodations. So that's
not exactly correct.
Well,
What happened in the Anoka lawsuit is they only had a definition in their ordinances of a family being 4 persons.
Right.
They did not have the presumption that this city has based
Which is
upon.
why I asked the question, do we
Right.
have anything that says reasonable accommodations?
We do for the 8 people in a group home. It's a reasonable accommodation for it to be 8 unrelated persons. We've got that. And we've had that. The second thing is that while they reversed the decision, it was only reversed at summary judgment stage because the court found there was a genuine issue of material fact, and that was because the arguments made by the entity seeking the group home permit said that they needed the 7 or
Yeah,
people
7.
for it to be financially feasible and for it to provide the proper therapeutic community. However, they did not present that information to the governing body. It was presented in the lawsuit through an affidavit, and the district court judge considered the affidavit, and the Eighth Circuit ruled that that was error, that should have been considered by the governing body before the district court can rule on whether it was in a violation of federal law.
Okay, but those are 2 items that they discussed in that lawsuit. And that's why I asked the questions about what do we have in the city of Little Rock that falls along those lines. We got a document that's a joint statement of Department of Housing and Urban Development, and it's for state and local land use laws and practices and the application of the Fair Housing Act. When this group came before the Planning Commission, I know Mr. Jordan announced that the Planning Commission supported it with the numbers, but they were told by the city attorney that they could ask no questions and they could not turn it down. And particularly on item number 27. When I look at that document that I just outlined, there's an item 21 on here, and it talks about reasons that a government could deny a group home. And it goes through some situations in there where it talks about if the zoning, if the request is for reasonable accommodations, it could be denied by the local government. If the accommodation is not reasonable, it would impose an undue financial administrative burden on the local government or would fundamentally alter the local government's zoning scheme.
That's correct, but
what do you
that's
have
in
to say
light of
about
them
that?
not having the provision we have about the 8. So that provision places the burden upon the opponents, not upon the applicant as to the 8. The 11's a different issue. There's no question about that. But as to the 8, this board's already made the legislative decision that if it is 8 unrelated persons, then it is presumed to be appropriate and necessary.
Was that done in an ordinance?
That's how it's set up, yes, ma'am. I will send you more on that Friday.
Yeah, because I don't recall doing that. Okay. That's the end of my questions today, but I wanted to get those out there to try to understand where we were on both of those issues. Did we determine that we had, that there was a financial burden on the city for either one of these items?
I know that the issue came up with the one that's on the street, and I can't remember the name of it,
That's the
between
one with
Markham.
11, the one with 11 in it?
On this one, I don't know. No, this is one that happened before that's on the way to Presbyterian Village. There was a outcry on that, and I know that a lot of questions came up like that. I was not at the Planning Commission, so I'll have to go back and look at the tape more carefully.
Okay, so you're not familiar with what happened at the Planning Commission then?
I'm vaguely familiar with it, and I've tried several times to read it uninterrupted, which has just not been possible. I'm also aware of the case law in this circuit, and particularly the case law within this federal district, where those arguments have been pretty much shut down completely by the federal district judges here.
Okay, well, I look forward to seeing your information. Thank you.
Thank you. I need to impress upon the board today that the 8 poses an issue for the board. The 11 has an issue, but poses less of an issue for the board because the ordinance doesn't say that that is any presumption as to the number. It exceeds the number that the board has already taken as reasonable.
All right, thank you, City Attorney Carpenter. Mr. Sarpy, if you will, we'll now transition to our MHA update. If you'll bring up the slides. We don't have to go through all the slides that you went through a few weeks ago, but just kind of get very swiftly give a recap of where we are today and some looming decisions that we need to make based off of the courts.
Just keep going. So as the mayor said, this is just a building up on the slide deck that we went over several weeks ago about MHA and Madison Heights 1 and 2. There we go. All right, so just following the foreclosure hearing that they held on the 29th. So a 90-day continuance was granted, which provided MHA time to find potential options to meet their outstanding obligations of the CAHC, and also allows them time to make repairs and rehabs to Madison Heights 1 and 2. So
May I add just one thing to that? There was another agreement, and that is that if the actions have not been taken by August the 1st, which I think is the 90th day, and it may be a different one, but it's right there in that Zoom, the Metropolitan Housing Alliance has waived the right to challenge the foreclosure.
Carry on. Thank you, City Attorney.
So what steps have the city and MHA taken since the hearing? We requested MHA get an appraisal for their offices at 100 Bruce T. Moore Way, which used to be Arch Street. They have completed the appraisal, so we have that information. H&P staff have gone out there and walked through the property and made assessments of the vacant housing units. And then we've opened up dialogue with local financial institutions as well. So where does that leave the city as far as our options go? We can loan up to $7.5 million to MHA. We can issue a short-term note for up to $2.5 million to acquire the property at 100 Bruce T. Moore Way. And this would be paid over 5 years from general revenues of the city. And then it would take about 60 days for us to do bidding, to do the protest period for a short-term note, and to get it closed. So we'd have to have approval to move forward this month in order to meet the 90-day timeline. And that's it. Any questions?
And before we go to questions, again, as we all know, the short-term note takes a while, and this city board has shared that your preference, if we have to make a decision, is to utilize a short-term note rather than reserve funds. And so if we have to make a decision, we need to make a decision. And the decision is, as our CFO has shared, we do a loan to MHA up to $7.5 million, or the loan of $2.1 million. We've talked through that scenario as well. Or, so those are the two options. And so I want to make sure that everyone is aware that we do have this looming timeline. So between now and the end of the month, we need to get a ordinance to you all for a vote. The judge did, he was aware that both myself and the city attorney, I believe also City Director Adcock was there as well, And basically, when Mayor Stola, on behalf of the Metropolitan Housing Alliance, he's back there in the back, one of the things that they share with the judge as well as with the bankers is that we're working on these financial options with the city. And so I don't want us to be afoul with any judge in our credibility. And so we will bring something to the city board for a vote. Whatever that is, we'll see how it turns out. But those are the options that we see today. Director Compuris. Can you do it again? You tapped it off.
Thank you. Nick, I appreciate what you've done. The question that I have and have had all along that I asked Tom and I've asked that we've gone back and forth on is who is Metropolitan Housing Alliance and who do they responsible to? In the time that I've been on this board, I've never seen an audit from Metropolitan Housing Alliance to us. The one thing that we have done is that we have approved members that they bring to us, and we have taken away members in the recent past. So I don't know whose responsibility it is. Is this a state entity? Is this a federal entity? But it looks to me like we're the ones stepping in to help something survive, and I'm not sure that's our responsibility. And I'm not sure if that's the way we're supposed to spend money. And until y'all can prove to me that we're really the organization between the federal and the state and us that have the fiduciary responsibility for MHA, I'm not going to vote for it. And that's that's the big issue. I can't listen to the people that come down here every time there's an apartment building in trouble who say, fix this up, and we're going to take, I think on dubious terms, city money to buy a building, and you're going to say to me, oh, we're not really doing that. We're not really helping them. But the whole purpose is to get around that, to buy a building so they can have some money to fix up these apartments on the idea that this will be able to cash flow over a 5-year period of time. And I think that's, it's a very clever way of doing it, but I don't think that's the right thing to do. But until someone can tell me conclusively who is in charge of this and how it's landed in our lap, I'm not going to vote for it. And that's the real issue. I mean, the issue is that we need to help keep those apartments in circulation. We need to help the people that are in them have a place to stay, but we need to do it legally. And to my way of thinking, and I have spent a long time writing those questions and asking people, asking outside lawyers, who is MHA? No one can tell me, and who's the fiduciary? Who has gotten the audits for the last 25 years that we've been on this board, that Joan and BJ and I have been on this board? I've never seen an audit. When's the time that someone from MHA came to us and said, well, let's tell you what we're doing. If it hadn't been for Joan Adcock smelling a rat over there, we would not know anything about it till this thing went down. And so your job, besides talking to financial institutions and bringing us an ordinance, is convince me, and there's plenty of people, you can get 6 votes, but you got to convince Dean Compuris that I have the fiduciary responsibility to save this organization, and that I'm going to be able to look all these other people that come up here in the eye and say, I know that you're in a place that we didn't do a good job of surveying, but we did this because we had the fiduciary responsibility, and that's what the big issue is. So you don't have to answer tonight. You can't answer tonight because no one can yet. But I'm asking a lot of people, and that's the issue that I'm going to be talking about for the next 2 weeks.
Director Hines?
Thank you. Tom, so kind of going into what Director Compuris was saying, let me see if I can recite this in a way that helps Dr. Compuris, and it also makes sure I got my facts straight. So this is a federally recognized entity created by or allowed by federal statute, correct?
It's allowed by state statute pursuant to a federal act on public housing.
Okay. And then the city created it by city ordinance under the state statute and the federally recognized act, correct?
That's correct.
Okay, so we did create it as a city, and, okay. So that leads me to my next question. So is this a quasi-autonomous body like that of the Airport Commission and the Sanitary Sewer Commission, or
No.
Water Reclamation? It's not. Why not?
Well, in those two instances, the properties that they own are owned by the city of Little Rock for the use of, or on behalf of, the Sanitary Sewer Committee, and on behalf of the airport. If the city, there's a little technical question as to whether bonds are outstanding at the time, but if there's no bonded indebtedness outstanding, then the city could abolish sanitary sewer, could abolish the airport commission and make them simply departments of the city and take them totally within, and then the aspect of the property being the city's for theirs would go away, and it would just be the city's property. These properties won't become ours.
Okay, and that's a whole nother rabbit hole. But, and I guess where my disconnect is, we have the authority to disband the MHA board, but we can't take it over?
No, you do not have the authority to disband the MHA board. You have
We
the
have
authority
to remove their members.
commissioners,
Okay,
but then you have to reappoint new commissioners.
okay, all right, that's where I was kinda, so we can just remove them, but we can't disband it. We can't, take the ordinance that we voted on to create them and do away with that ordinance?
It's not a city entity, it's a state entity.
But Tom, that's where this is like a catch-22. It was created by city ordinance.
No, it was created by a state statute where the city had the option to create or have within its jurisdiction a housing authority. It also had the option, Pulaski County had one, and the city could, if it wished to do so, like they have in eastern Arkansas, develop a regional housing authority of several cities.
Okay. But, and I guess that's where my disconnect, but you just said earlier that we did create a city ordinance that created the MHA.
Created the ordinance pursuant to statute that allowed us to have a housing authority, which was no different than creating a district court pursuant to statute to allow us to have a Little Rock District Court.
Can we not uncreate those?
No, the Arkansas Supreme Court ruled in a case out of Cabot that even though we can create it, we can't abolish it. And it ruled in a case out of Fort Smith that even though we appoint the members, it's a state entity.
So we're stuck with it, is what you're telling me.
No,
And
there's things you can do. The statute was originally, the state statute was originally challenged because the first year's operating expenses had to come from the creating city.
Right.
I'm not going to talk about counties because I'm just here with the
Right.
city. And that was mandatory. The Supreme Court said fine. That same statute says that from time to time, a city can loan money to a housing authority. So you're not
that's
just
where we
stuck
are.
with it.
That's where we are. All right, thank you.
Director Miller, then Vice Mayor Wyrick.
Thank you, Mayor. Just a couple of questions. Because I don't want to get all in the weeds. I hadn't been in the meetings. I hadn't been in the room with all these attorneys talking to each other, but just some general stuff. What did the property appraise for over at the Bruce T. Moore Drive, the corporate headquarters?
2.11 million.
2.11?
Yep.
And what are we talking about loaning?
So the loan would be in accordance with state law where we have the authority to loan MHA money.
Yeah, I mean, how much were we talking about?
So it'd be, we're saying up to $7.5 million to pay off all for them to manage their financial situation because we can only loan money to MHA.
So what's...
So I'll get in there. So members of the board, if you recall, Mayor Stodler, the CAHC chair, Mr. Baker Curris, and the MHA chair, Mr. Kerry White, they proposed to this city board, one, they requested the city board's help in this issue. As we all know, they are new because we replaced them. And so they've done a lot of due diligence to get to this. It's basically a workout, a bank workout. And so now they propose an option. The option is we loan them $7.5 million. 5.4 will handle all of their bad debt, interest, and legal fees. That'll take them out of the special acquisition company, which is a private equity firm, not a traditional bank. That'll pay them off, and then the remainder, $2.5 million, will go towards the 50 vacant properties that our code enforcement has done an assessment alongside our fire marshals. And the thought there from Chairman Wright and Curris is to make that investment of the $2.5 million in those 50 vacant properties and add additional cash flow to what's already in the rents that they are receiving right now, both from public housing and from market rate. As you know, the interesting thing about Madison Heights 1 and 2, it does have a component of mixed income, where 75% of it is public housing, Section 8 vouchers. The other 25% is actually market rate. And so their option is 7.5. What I gleaned from many of you, because of some of the questions, there is this question, is it really our responsibility or not? What I gleaned from you all is, one, you first shared with me that you didn't want to utilize the reserve funds. You want to take a short-term note, which is what we have before you. Secondly, for some, there may not be an appetite for 7.5, maybe appetite for 2.1. And really what we're looking at right now is a public policy decision and a political decision. The public policy decision is these residents are different than other folks who may come to us like a Big Country Chateau. And when I say they're different, residents are never different, but from the standpoint of Big Country Chateau is a private company. This is a public housing apartment that receives public dollars that we all play a role in, whether it's HUD funds, home funds, CDBG funds, that we all together vote on day in, day out. And so those particular residents are different because they are receiving subsidized payments for their apartment versus someone who is at Big Country Chateau that are not receiving subsidized payments. So that is the public policy difference. And from a political standpoint, board members could say, we helped out a government entity. We do not help out private entities. There's a process for that. And when we do engage with private entities, it's through our code enforcement and ultimately through the courts. And so there is a clear delineation in helping out our residents who are receiving subsidized loans. So the question before the board, because the city attorney and myself, whether we have responsibility or not, as Director Hines has shared, this city 30, 40 years ago, or even before I was born, decided to take on the option of having a housing authority. We're here now. And the question is, in 90 days, are we going to aid them or we're not? That's literally the question we have. But since the city attorney and myself and City Director Adcock, we went before a judge, and I like to always maintain my credibility with the judge. And this board also gave a motion to vote to find options. We're coming to you with options. This board has to vote. We got 90 days. I'm going to keep my credibility with the judge. We're going to have an ordinance. And so we hope it can be a unanimous, but we also know it may just have to be 6, or it could be nothing. And that's the public policy and the political decision that we all have to make.
Okay, thank you, Mayor. I appreciate that. And I certainly want to keep housing available to these residents. Certainly appreciate all the hard work that's gone into this. I just want to also know that the buildings, Madison Heights 1 and 2, what did they appraise for? Did we get appraisal on those?
We don't have a current appraisal for them, no.
The last appraisal that was on it was $17 million, and we feel very comfortable that it's still gonna appraise at that. The reason why, and I'll just to answer that question, the reason why the city attorney and I were just kind of bouncing around ideas, and as I shared before, if Director Hines and I are on one accord on something, let's just go ahead and sign the deal. And it's kind of the same thing, not necessarily the same thing with the city attorney, but he and I were just literally spitballing and came up with the idea because we knew there many board members may not want to do the 7.1, 7.5. And this is a way, one, that we're not spending as much from a short-term note. Two, we're able to get a property and that's well collateralized that the city can use in the event that the MHA doesn't pay us back, and we can move. As we all know, we have some different staffing needs, whether it's with 911, whether it's with the courts until we get the new courts built, things of that nature. There's so many different things that we could utilize that property and literally lock up the lot of Markham.
Yeah, I have no problem with that. I think that's a great idea to try to get that property. But on Madison Heights 1 and 2, I mean, you say the latest appraisal was 17 million. Was that based on all of the units being rented? I mean, because we have how many units not available? How many? So we got 52. So I wouldn't think that property would appraise for this much if there are 52 units that are vacant and not throwing off any cash flow.
When it was done, those units were probably still vacant, I'm pretty certain, but we can get you the most recent appraisal.
Yeah, and so we can't get that property? Madison Heights 1 and 2, I mean, I know the option, you're giving us two options. I'm just thinking out loud here. Again, I hadn't been in any of these.
Option one is getting that property. So option one, we will be taking over Madison Heights 1 and 2 and that cash flow.
So, and of course, at this point, we don't know how much that cash flow would be.
Right.
Should we know how much that cash flow would be?
Yeah, 200,000, I think.
I mean, everybody agree with that?
Yes. I looked at the number. I didn't have that number here, but I have looked at the number. It's a good bank deal.
So the building itself, are those tenants given the vouchers, or is that property, those vouchers go with the property?
At least
Kevin, you
until-
have to answer that question. I don't know that.
At least until the end of the year, they definitely do.
Director Miller, it's a mixed-use property. It's only about 20, yeah, it's not that many Section 8 vouchers. The rest of it is market rate.
So 25 vouchers go to the tenants, they don't stick with the property?
Those are not project-based vouchers.
Okay.
Those are Section 8
So
vouchers.
if I didn't want to stay there, I could take my voucher and go someplace else?
That's correct.
Okay.
I'll just wait if you ask me another question.
That's fine. No, again, I appreciate all the hard work. Don't get me wrong. I'm just trying to get a understanding about some values here, based on the appraisals that we have and based on the old appraisal. Also, I want to know in these discussions, has the state been involved at all? Has the Attorney General been involved at all? Has HUD been involved at all?
HUD was involved to the extent that there was an effort in November or December to get funding by the local HUD office, and my understanding is that was denied. The state has not been approached, as far as I know.
Okay. Does the state do they need to be at the table? I mean, Mayor, I know there's a 90.
We'll bring Mr. Howard to address that, but also I want to make sure we also are clear too, just because of recent legislation, the entity that we would approach, there may be some challenges there because recent legislation, they're going to be privatized in July.
And just to answer your question, so MHA Director Dr. Jorman did reach out to the state to request some additional funding through Arkansas Development Finance Authority. And just based off the information that I received, they were not going to allow any funding towards the project for Madison Heights 1 and 2.
So they were approached?
Yes.
Okay. And does HUD have this still talking about the unaudited expenses that were done? Of course, they threw out a number of 29 million that I heard somebody say as well, very highly exaggerated, but is that shadow still hanging over this property?
That would be do you want to answer that question?
Mayor Stoller, if you approach the podium, I know you're not shy.
Good afternoon, Mayor and Board.
Good afternoon.
Nice to see you all. The question is, the initial discussion, I think, about the audit and the money has been largely resolved relative to that large number of $29 million. There is a current investigation that's going on that is pending. The information that I've received does not suggest that the numbers are anywhere near in that type of range. And that's about all I can say about it, because that's about all I've been advised of by the people doing the investigation. I will tell you that from an audit standpoint, the audits have been complete, and certainly they can be provided. The new board has been working very diligently to update the financials as it relates to both the Housing Authority and to the Central Arkansas Housing Corporation. And so certainly those numbers are available.
So, well, I appreciate that. Thank you. So there's not any contingent liability that you are aware of on the forefront from HUD?
No, there's not from HUD.
Okay.
No. And as a matter of fact, that office has been disassembled, I guess is the best way to put it. The acting director that we've been working, or not the acting director, but the director that we've been working with is no longer here. And so we are going to be working with apparently a regional office out of Oklahoma.
Okay, thank you. And are you familiar with the property that is being sold by, is it MHA or CA?
The properties, yes.
What's the timeline on those properties being sold, and is that going to throw off any equity?
It's going to throw off some funding, but it's funding to the Housing Authority as opposed to the CAHC, and it is certainly properties, money that can then be used for public housing.
Do we know how much money that's going to be?
Well, it's about $1.6 million collectively. There are 3 different properties. One has closed. The other 2, there are contracts on. There are some additional work that has to be done on the gymnasium, subject to ultimately it closing. And that is, of course, that's been an issue that I've been trying to, and I think Mr. Carpenter's been trying to get an answer on. Somewhere back in 2005, the city of Little Rock proper leased a housing authority property to the St. John's Church, and it was to be used and continue to be used as a gymnasium, and also they were allowed to use it on Sundays. And over the course of time, apparently all of that has changed, and it has not been maintained by either the housing, by St. John's, who had the obligation under the lease to do it, and also monitoring by the city, which I think in retrospect was not done either. So in any event, we've got an offer on that property. It's substantially more than what the initial offer was, and if we can figure out the repairs for it, there's been one estimate of about $69,000 to repair the arch supports that there are that hold that kind of a Quonset hut gymnasium up together. So we're trying to get some other bids on that to try and see if we can reduce the cost of that so that we can get this property closed.
Yeah, that's fine.
Director
Sorry, I
Miller,
don't really want to go ahead.
the city did a title search. I don't know where the lease came from, but the city has no interest in that property, no legal interest.
Seems like there may be a difference of opinion here.
There's a year and a half remaining on the lease contract that the city signed. I'm not sure what that means, but
That means we signed a lease that is not enforceable because we didn't have an interest in the property. I didn't see it.
All right, I don't.
We'll handle it outside this
Okay.
meeting.
Again, I don't want to get in the weeds, but also, let me ask, whatever funds those properties throw off, is that part of what we're talking about, Mayor? Are we in our negotiations saying that any funds that the sale of those properties throw off goes towards us or goes towards the fixing of these units? Where's that money gonna go towards? And are we tying that money up if we step up and bail these folks out?
We can and definitely will have some thoughts and that we'll put on paper, and it is tying up different things as they get new money, but they also, to their own credit, not credit, but to their own advisement, they also are in the rears on other areas as well. And so those dollars are going towards those things. I think we all know this city board, this is not anything new to the city board because this has been going on for a couple of years now.
Yeah, I appreciate that. Thank you, Mayor. And I want to make sure, of course, you're going to bring us the ordinance. I appreciate all the hard work on that. And I know we're getting two choices, so thank you on that. But I also want to make sure that we know what we're getting into. Like you said, they have some other obligations. Do we know what all those other obligations are? Do we know what we're stepping into as it relates to what else they may have obligations for?
We can get you that whole list of obligations that they have. They definitely don't mind sharing that. They have been working out of that. What I would share is when we step into this, we're only stepping into this issue. This is the only issue we're stepping into. We're not stepping into any other legal issues that they may have. And that's the reason, under the advisement of the city attorney, we have to do it the way that we're doing it, by loaning the money to the MHA. And MHA is going to, because it's going to get into a lot of legalese, the note is with CAHC, which is a subsidiary nonprofit allowed by the federal government, created by MHA. And controlled by MHA. We are only loaning money to MHA. And so essentially we have to put certain things down. I'm on TV right now. Certain things down for the short-term note, but the note is going to MHA, and MHA will then disperse towards CHC, and we will lock that up. I can promise you that the city attorney is going to lock up everything we can and make certain things are cross-collateralized from that standpoint, because quite frankly, nobody's signing on the dotted line. When I say there's no personal guarantees in this type of loan, it's on the full faith and credit of the city that we're giving this. And then we're taking a full faith of the new board that this city board appointed to carry out and execute this loan. So essentially, this is our loan to an organization that this city created 40 years ago, that this city board also replace the new board to carry out. They're doing what we've asked them to do. They're working out the issue, and this is how it gets worked out. Again, it's a political decision for the city board on how they vote. It's a public policy decision on how we vote. From that standpoint, I'm gonna, like I said, I heard you. I think there are some city board members think we should just do 7.5 and just be done with it. Others want to do the 2.1 because it's just lesser. We got to make a decision because on August the 1st, it is foreclosing based on what the judge has shared. Am I correct, Mayor Stodler?
You're correct, Your Honor.
Okay, thank you. I'm not gonna, I'm gonna leave.
You never called me Your Honor.
Do you like that, Mayor? I don't think I was ever called Your Honor when I was sitting there. But,
Well, I appreciate it. I may have some more.
I'm
but I
used to
don't
saying that now.
Yeah, I don't want to.
I would like to just say that MHA is a DBA. It is the Little Rock Housing Authority. It always has been that.
Okay, all right. Thank you, Mayor, for
And that's how it was created in law. Yeah.
indulging me on that.
Director Miller, one thing that the city can take some comfort in is that the CHAC board now is not the same as the MHA board. So it won't be the same people agreeing to do something. It will be two people working at arm's length.
And for members of the city board, I just want to reiterate, to keep the people, the residents of Madison Heights 1 and 2 front of mind in this decision, because ultimately it's going to impact them. They're the ones with the subsidy. They're the ones that are living there, and they've already been before us, and rest assured they'll be back. And so we need to make certain that we have a plan for our residents. Whatever that plan is, we need to be resolute with what this city is going to decide to do. I'm not going to come before you with two ordinances, unless I hear that I probably need to do that. But more than likely, it's just going to be one ordinance for you all to decide upon. What I'm asking is, would you rather the 2.1 or the 7.5? I can say that publicly. That's not polling when you're public, right, Tom?
It's polling, but it's not binding because you're not in a meeting.
Right.
And it is public.
It is
All right.
public,
Yeah.
yeah.
So do I hear, is 2.5 a better option? I see Director Hines, you had your hand up.
So I'm going to give you my thoughts real quick.
Please
Mayor.
do, yeah.
And Director Miller, so I got, the number of units is 241 units. So at a value of 17 million, that's $70,539 a unit. If you subtract the 52 units, that's 3.668 million. So you're still well above 10 million on a $7.5 million loan. So from a leverage standpoint, it's a good deal. I have some, I think if we do the smaller amount, we're kicking the can down the road because it does not solve their debt issue. They still have a lender. I think, I also think that if we hold the note, the issue is we don't hold the note, but since we have an entity that does have some influence at CHC, I think some discussions need to be had with some type of ownership interest being conveyed to the city, or maybe the MHA building being tendered as collateral on our loan. I have very big concerns about buying MHA building. I know that there was some talk previously about it. That's why we acquired one of the buildings. We don't know what kind of deferred maintenance. We've got an appraisal, but you never know what's in there. We do have a good idea of what's going on at Madison Heights 1 and 2 from a fire and a car wrecking into it. We know what the rehab cost is. They're roughly going to spend about $48,000 a unit to rehab those, but I think there's some other deferred maintenance at Madison Heights 1 and 2. It'll be more than just those 52 units. From just a purely business deal standpoint, the asset's better on that. And then I guess the question is, how do we collateralize that, Tom, if we can? Since MHA does have influence over CHC, there may be some type of understanding or agreement we can get to there, as well as a buy-sell agreement going forward. But I think if they can get this property rehabbed in unit and generating, then maybe it becomes a bankable deal where we're not the lender of last resort. I think that's kind of where I'm at, is on the larger amount, because it ties it up in a bow. It gets us essentially as the lender on it. And we've got some strings we can pull there. So, you know, I just, the corporate office building just, to me, is not as good a deal. And I just think we kick the can down the road and we'll be back here. It doesn't give them the funding they need to resolve the issue.
Totally agree with you. Vice Mayor Warwick?
Thank you, Mayor.
No, you were, got it. You're on.
The mayor's in control of when I speak and when I don't speak. This kind of reminds me of municipal improvement districts. I know it's a lot more complex than those, but on those type of districts, we appoint commissioners and then we remove commissioners. And whatever happens in the middle is all done by a civilian government. So this is kind of what this reminds me of. I know it's a much more complex situation, but I kind of agree with Dean. And, you know, is this our responsibility? Those kinds of things that he said. I worry about I know there's some other liens, debts out there, and what if somebody comes to us and says, okay, we got this issue, or we're gonna take over Madison 1 and 2. Nobody's said what those other liens and debts are. The question that I really have is, can CHAC or MHA not use the administrative offices to get collateral so they can get their own loan of 2.1 million? Why do we have to be involved in that? Is their credit so bad? Are they so far down the tubes that they're not able to garner their own money to get them out of this situation? Have they tried that?
Yes. It's that bad.
Is that bad?
Yep.
Okay,
All right,
it's over.
Director Adcock?
I will be supporting the 7.5.
Yes, ma'am.
I've worked with Mayor Stoller and with Baker, and both of these gentlemen, this is what they have suggested, and I will be supporting that.
Yes, ma'am. I agree
Thank
with you as well. All right, Director Capiers.
Kevin, quick question.
Yes, sir.
Thank you. How many units are there?
It's 271 units from what I originally heard, and when we inspected 301 units.
And how many voucher units are there?
I believe it's 25.
And the rest are market rate?
That's correct. I don't know if they're charging them market rate rent, but they have the option to.
Thank you.
Any more questions?
Mr. Howard?
Yes, ma'am.
Mr. Howard?
Director Howard?
Yes, ma'am.
Over my 32 years here, Big Chateau was not the only apartment complex you've gone in and cleaned up.
That's correct.
What is the cost, or what did we put into Big Chateau?
As far as the timeline that we inspected, the number of units, as far as staff timing and
And all the
and
money that
moving.
we paid rent?
Yes, it was probably close to 150,000 that we put in, just moving those tenants out of the apartment complex. It was probably close to probably 70. When we finally got to the end, it was probably 70 units that was occupied. And it was close to 8 to 10 buildings. They had a laundromat too, but a lot of those buildings had been boarded up and secured, but we had to go back into those and inspect those units at least 4 or 5 times before we got them out of court, before it went to receivership. And so we were in the process of moving individuals out. At that time period with Big Country Chateau, we had some individuals that was staying in units that was not paying rent at that time period. So they didn't have a cash flow like Madison. And they have some cash flow at Madison versus what was done at Big Country Chateau.
Okay, so it was around $200,000.
Yeah, it was close to that.
And what did that money come from?
Came from the city.
Okay, out of your budget?
Yes, ma'am.
Okay, thank you.
Director Miller?
Thank you. One other question, Kevin. I know you have a rent roll. You got a
Yes.
rent roll of the property, so you'll know how many units we have, and taking a look at the rent roll, you'll know what's market rate.
Yes.
Okay.
Yes.
All right. Thank you.
All right, members of the board, also, I want to ask Miss Kennedy Stanley to come speak. She wasn't able to get the photo with us. We'll do that after the meeting. But I wanted to give you your opportunity to share as well.
Good evening, Mayor and Board. First and foremost, I want to apologize for my tardiness, but I want to thank you for the proclamation today. It's very important that we celebrate mental health every day, but especially in May. I think it's important for us as residents of Little Rock and Arkansans to unify as a unified front and come together to raise awareness, break the stigma, and promote positive conversations about mental health. So thank you, Mayor Scott, for the proclamation, and I hope you all have a wonderful day.
Thank you so much, Ms. Stanley. Let's give her a round of applause as well. Mr. Sarpy, if you will prepare an ordinance for the 7.5, and we'll add that as a modification. And does that meet your timeline? Because we don't want to get in trouble with the short-term note stuff.
If we're doing it as a short-term note, then yeah, it'd have to be next week. The only thing is we have to have assets. So we have to have tangible personal property in order to do a short-term note for that amount.
Gotcha. All right, so prepare for the 7.5, and you and the city attorney will work out all the documentation for the board's consideration for a board vote. Thank you, members of the board, for the thoughtful consideration and thoughts about what's vital as it relates to the residents of Madison Heights 1 and 2. Thank you so much. Anything before we end? Anything before we end? Meeting adjourned.